All right, good afternoon. We're about to start the immigration panel. We'll have a break after this panel. My name is Avi Cover. I head up the Institute for Global Security Law and Policy here at the law school and also run the Civil Rights and Human Rights Clinic. Very pleased to be here with our immigration panel. We're going to run this in sort of a more conversational style. Both panelists will talk, make some initial preliminary remarks, and then we'll have a bit of a conversation, the three of us, and then we will open it up to all of you, and hopefully we can budget that time as we aim to do. As Jeffrey Stone observed this morning, EO 9066 may be viewed as the tragic but logical outcome of a 100-year-old racist and xenophobic immigration policy that had prohibited the entry of Japanese nationals in 1924. Last May, arguing before the Ninth Circuit, the government's attorney defended the president's second version of the travel ban, saying, this is not Korematsu. I guess the question has to be asked, is it? And if the ban is not, is it then a precursor, just as the Japanese exclusion was to Executive Order 9066's exclusion and internment of Japanese American citizens? Our panelists, we have two wonderfully distinguished panelists today to discuss these issues. Professor Peter Margulies, I'm not going to go into their whole biographies, but is a professor of law at Roger Williams University School of Law, has written extensively on issues of immigration and national security, has been an active litigant in these issues as well. Professor Hiroshi Motomura is a distinguished professor at UCLA with numerous books on these very issues to his name, and in particular has a book right now in the works titled, I don't know if it's still titled Migrants, Refugees, and Citizens. Is that?
It covers pretty much everything.
There you go, there you go. So we couldn't be more pleased to have these two individuals. Peter's going to speak first, just briefly helping us better understand the modern development of U.S. immigration policy, including a progression from, albeit a tension, between sort of vast executive discretion and limitations on discrimination that Congress has over the years imposed. And then Hiroshi will talk briefly how the executive order and the travel ban evidence national security-based immigration measures impact on not just would-be immigrants, but on U.S. citizens themselves. So I'm very pleased to sit between these two giants. I'll slouch down.
Okay, good. Okay.
Thanks very much. Avi, thanks very much for that kind introduction. I got to say, I'm most privileged to be on this panel, not only with you, but also with Hiroshi Motomura. I remember when I was doing an immigrant rights clinic in Miami, Florida, about 25 years ago, and sat down in a neighborhood deli, and I read Hiroshi's landmark article, Phantom Norms and Immigration. I just looked at it and said, you know, that's it. That is exactly the way we have to think about these issues. And then my next reaction was, I wish I'd wrote that. So it's a privilege, as always, to be on a panel with Hiroshi. The remarks I have today are going to actually start with a little bit of an Ohio link per the last panel. And this one involves a representative, a very important representative in 1965, who was chair of the Immigration Subcommittee of the House Judiciary Committee. His name was Michael Feigen. I'm going to pronounce it Feigen unless I hear differently. He was a Democrat from Ohio. He actually had been a kind of hardliner on immigration until he got the treatment from another president. We heard about Warren Harding earlier. Now he got the treatment from Lyndon Baines Johnson from LBJ. And that had a pivotal role in enactment of the 1965 amendments to the Immigration and Nationality Act. That made a huge difference in our immigration law, difference in terms of fairness, equity, reasonableness. Before I get to that, though, I want to go back in time to the 1952 Immigration and Nationality Act. That was a very, very different kind of statutory animal, because that really led us to question, in light of what we heard this morning, what had we learned, right? The 1952 Act was an exceptionally rigorous, I wouldn't even say rigorous, just really heartless, is a better way of putting it, piece of legislation. It was a bill that set up a quota system, or perpetuated a quota system for countries everywhere around the world. It led to a particularly onerous quota system for what was called the Asia-Pacific Triangle, namely every country in Asia. Folks in the Asia-Pacific Triangle, you may have heard that's a pretty populous area, were limited to a grand total of 2,000 annual visas. 2,000. That's, what, like 1/20th the population of this entire campus, right? That's all the visas that were available to Asians, and more. It also included persons of Asian descent anywhere around the world. So if you were a person of Asian descent from Latin America or the Caribbean, you had that same quota that you had to fight with and wait on until you could actually get a visa, given that you would have a close relative in the United States. That's how inhumane the system was. What did our presidents do in response to this piece of, again, heartless legislation? President Truman thought that the best course of action was to do what he felt comfortable doing and getting the work product he occasionally got from our Congress. That is, he vetoed it. Unfortunately, Congress overrode his veto and enacted the legislation into law. In the course of vetoing the legislation, Truman, who was not reticent, said exactly what he thought of it. He said that it was discrimination pure and simple. That verdict was considered exactly the right verdict by subsequent presidents. President Dwight Eisenhower, Republican, said that the legislation was inequitable. He considered it to be a throwback to a day that had long been discredited. Similar verdict was delivered by Eisenhower's successor, President John F. Kennedy, who said that the quota system was lacking in all reason and logic. And finally, Lyndon Johnson, after John Kennedy's untimely death, had his own special verdict about the quota system. He said, echoing the famous passage in President Kennedy's inaugural address, that what we should do with reference to immigrants is we should ask what they could do for our country. We should never ask, what country are you from? Finally, in 1965, Congress heeded President Johnson's call. In the landmark legislative amendments in 1965, shepherded in part by Senator Ted Kennedy, who made immigration a lifetime calling of his, Congress abolished the national origin quota system. They relegated it to the dustbin of history. Instead, Congress elevated family reunification to the front ranks and said that's the foremost consideration of our immigration law, making sure that U.S. citizens and lawful residents could get reunified, get united again with family members abroad, spouses, parents, and kids. Another feature of this act was shepherded by none other than Ohio's Michael Feigin. Representative Feigin reacted very badly to an administration proposal to continue a measure of administrative discretion. So the administration could still say, well, we have some quotas or quotas in reserve, and we'll kind of juggle different countries, what allocation they get from this reserve quota system in keeping with what we see fit. Representative Feigin would have none of it. He told his colleagues in Congress, and he told Secretary of State Dean Rusk in testimony before the House subcommittee, that this lacked checks and balances that were necessary in immigration legislation. It would lead to runaway discretion on the part of the president. As a result, Congress, at Feigin's insistence, passed what we now know as the non-discrimination provision of the Immigration Act. That's at 1152A1A. That provision simply says there's no discrimination based on national origin in the issuance of immigrant visas. So to recap, the 65 Act abolished the quota system. It elevated family reunification to the front ranks. It outlawed discrimination. And it did all that in the interest of what it said would be a fair, rational, humane policy that was in the public interest. Those are the assumptions that we made in 1965. That was the verdict of Congress and successive presidents, Democrat, Republican. And that's pretty much the understanding that remained from 1965 till January of 2017.
Well done.
Okay.
Well within 10 minutes.
Yeah. Thank you. It's great to be on a panel with Peter and Avi, and thanks to the law review. Thanks especially, Michael, for bringing us here. I know it takes a lot of work to make this happen. We really appreciate it. This is a panel on it's called Immigration, but it's in a event that's focused on Executive Order 9066. And so what I thought I would do is to try to pull these things together a little bit. And I've spent a lot of time, a lot of years, I guess, thinking about essentially how immigrants become citizens. This is really an immigration story, but it really tries to look at where we find the law, or where we find not just law, but society making or managing that transition from immigration to citizenship, or immigrants to citizens. And so in that frame, I thought what I'd do is to suggest a way of thinking about the connection between Executive Order 9066 and the current travel ban, and in particular travel ban litigation, and what the Supreme Court's been doing and what may happen. And to really fill that out, I have to give you some intermediate points in the form of some Supreme Court cases that take place that are decided between the 1940s and the present day. These are cases that are familiar maybe to a lot of immigration law scholars or lawyer types, but maybe less well known than some of the cases we were talking about earlier. So the connection and the hook with Executive Order 9066 is a phrase that doesn't actually appear in the executive order, but appears in the exclusion orders that were used to implement the executive order. The exclusion order is actually ordering people to report persons of Japanese ancestry. And what follows the words persons of Japanese ancestry is both alien and non-alien. An intriguing phrasing, the word non-alien, an obvious attempt to avoid the word citizen. And I always thought that this says something, or at least provokes a lot of thinking about not just the deeper meaning of the incarceration or internment period, but really the meaning of citizenship itself. And it reminds me to think about the executive order as an episode, not just in national security, not just in the history of internment and incarceration, but also really part of immigration history. And so I guess my thinking is that to try to understand the executive order in that episode as part of the immigration story of Asian Americans to the United States. And the background fact here is that in immigration law, the law has not done very much recognizing how the immigration decisions of the U.S. government affect U.S. citizens. In other words, the construct really is that there's a border, we're here, you're not, and that arguments that have tried to invoke or cite, reference, document the impacts of immigration decisions on U.S. citizens have generally not gotten much traction. They might have won some lip service, but they've really not changed the results in cases. And so in that regard, let me just tell you about a couple of cases. One's called Fiallo versus Bell, F-I-A-L-L-O, Fiallo versus Bell. It's Griffin Bell. It was 40 years ago in the Supreme Court, and the case involved several families, fathers and their children. And the attempt was to have a petitioning process, the fathers sponsoring or petitioning for the children, or the children for the fathers. And the complication was that the fathers were unwed fathers, the children born out of wedlock. They were not unwed mothers. That would have made a huge difference. The immigration statute at the time had a blanket exclusion of this relationship from the very definition of a child. And so even though the child did recognize the relationship of a child to an unwed mother, and the family challenged the statute as unconstitutional because it discriminated unlawfully in violation of the Constitution's Equal Protection Clause. And so the Supreme Court took a narrow view of the case as essentially non-citizens trying to come to this country. And the court brushed aside the arguments made in dissent. that we really need to think about the fact that this affects the family rights, or however one would phrase that, the rights of citizens who wanted to live in the United States on the basis of their relationship with their children or their fathers. And so that prompted a vigorous dissent, but essentially the court really saw this as an immigration case, and it relegated to a zone where the Constitution doesn't apply that much. The courts applied what's called the Plenary Power Doctrine. It's been mentioned a couple times today. And this doctrine insulates the government's immigration decisions at least about who can come into the country and who may be deported from serious constitutional challenges under what you think of as standard constitutional doctrine. And so FIAO stands in this sense for the proposition that citizens who have concrete and serious interest in who is allowed to cross the border cannot rely on the Constitution to protect those interests, whether they be personal, family, or community life. So let me fast forward to the travel ban litigation today, and something interesting is going on. Although this is a story that's ongoing, and I don't know what's going to happen. We've mentioned the travel ban in several contexts throughout the day, and I'm less interested, for the purpose of just trying to fill out and instigate this part of the conversation, I'm less interested in the precise arguments about some are statutory, some are constitutional, and some are based on different parts of the Constitution, but I'm interested in what the Supreme Court did this summer. And we had some injunctions blocking the ban on a nationwide basis, and the Supreme Court stepped in, and it allowed the ban different ways to phrase this, but basically the lower courts issued an injunction against the implementation of the ban, and the Supreme Court said, well, you can uphold that injunction. In other words, the ban will not be allowed to go into effect, but it defined the zone of protected people, the people who will be protected by this ban, and the people who will be protected by the injunction. And it said that the ban won't be allowed to go into effect where the banned non-citizen has a bona fide relationship with a person or entity in the United States. And it gave several examples, including a mother-in-law, a non-citizen who accepted a job with an employer in the United States, a non-citizen who accepted an offer admission from a U.S. college or university. There was a lot of briefing back and forth about exactly what that meant, these things meant, whether it included a refugee resettlement agency, and I think a lot of the press on this issue had to do with the question of whether a grandmother was a close relative. Okay. And so and that's what the Supreme Court did, and that's what we're seeing now that case about version 2.0 has been mooted, and then we have 3.0, and now we have injunctions in lower courts. Earlier this week, the Ninth Circuit essentially took the Ninth Circuit's version of the injunction and scaled it to correspond to what the Supreme Court had done. So what you have here really is an injunction in the interim, which is really focused on protecting the kinds of rights. It might be, not sure exactly where it's going to head, but it looks like it's an injunction that's designed to protect the very sorts of rights that were not recognized in FIAO versus Bell, which is the case decided in 1977. And the Supreme Court, when it issued this decision in the summer, relied on another case from the Supreme Court in the 1970s called Kleindienst versus Mandel. And Kleindienst versus Mandel, like FIAO, is a case that the government won, and the people contesting the immigration decision lost. But Mandel is a case involving professors based in the United States who wanted to invite a Belgian Marxist named Ernst Mandel to come speak at colleges and universities in this country. And so the court allows the professors to bring the lawsuit, talks about the First Amendment interests, how the First Amendment interests would not be satisfied by, well, I guess Skype didn't exist then, but I don't know, telephone calls. There's kind of a quaint couple lines about how they could call long distance or something. But what's interesting about that is that too is a case where, like FIAO, the effect on the citizens doesn't really seem to matter. It doesn't seem to change the result. But what happens in the Supreme Court this past summer is the Supreme Court cites Kleindienst versus Mandel, not for its usual purpose, which is that the government wins, but rather for the purpose that there are interests here that really need to be respected. And it issues a preliminary injunction on that basis. I'm going to just quickly mention another case where I think the same thing is going on from the Supreme Court. Kerry versus Dinn, 2015. This is a case where you have a little more recognition of the effects of immigration law decision on a U.S. citizen. It's hard to count the votes in that case because it's kind of a 3-2-4 split on the court. But the point I'm just trying to throw out here for conversation and just for contemplation is that the Supreme Court is, in the preliminary injunction stage, looking at how it's going to define some combination of likelihood of success on the merits and irreparable harm, some combination of those things in a way that takes into account the effects on U.S. citizens that seems quite a bit more robustly protective than we saw in Fiallo versus Bell in 1977, in McLean versus Mandel in 1972, and is an expansive reading, I think, of the court's non-consensus in Kerry versus Dinn in 2015. I'm not sure if the court's decision on the preliminary injunction is a sign of how it may go on the merits. That's another interesting question. But I just want to throw this out and bring it back to the executive order and the concept of what it means to be a non-alien, because this may be, if you think about it in these terms, is transitioning from being an alien to a non-alien to a citizen, does that include some recognition in the law that your relationships with people outside the country in an immigrant community, does that include some recognition in law that those rights should be respected? If so, then you can really see a line from Executive Order 9066. Actually, you can see it from Asian exclusion to Executive Order 9066, where you have where the Japanese Americans become non-aliens, and then you see it with recognition in the travel ban litigation that the effects on citizens of immigration decisions are recognized potentially in a way that were not recognized 40 years ago, and certainly not 75 years ago. Thanks.
So I want, Roshi, you started, of course, getting into the court's summer decision, but I wonder, Peter, you sort of left us with a little bit of a cliffhanger, if you will, in terms of did everything, all the assumptions that were built into the 1965 INA regarding fairness, non-discrimination, family reunification, were they torn asunder in January of 2017? And maybe, I don't know, Roshi, it sounds like you're finding, maybe particularly in the summer decision, maybe some silver lining or the court's resistance to that. So we could hear from both of you on that.
So maybe just a tiny bit of background on the now multiple executive orders on immigration would be useful. So quickly, there's one executive order that President Trump issued virtually upon his inauguration. That's EO1, we'll call it. That's the one that targeted pretty much everyone from 7 countries. So that included Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. And so nationals from those countries were basically barred from entry into the U.S. That order didn't make clear that it excluded lawful residents. And so there was a belief that lawful residents would also be subject to this ban on entry. That is, people with lawful permanent residence in the U.S. who would be eligible to naturalize and become citizens at some point. Moreover, the order said that visa holders, current visa holders like student visa holders or business visitors, including professors who are working at campuses like this one, were also subject to the ban. And so that meant that, talking about January, that folks who are coming back from Christmas break to go back for their spring semester, right, wouldn't be able to come back in. That led to this chaos at airports that we're all familiar with, that Sahar referenced in her talk. So the executive order number 1 gave way after a couple of judicial reverses to executive order number 2. That was at least an improvement in that it expressly excluded from its coverage lawful permanent residents and current visa holders, right? But still left in place coverage for all the countries I mentioned, except for Iraq. It finally dawned on the administration that Iraq is an ally, and so we don't want to embarrass them by including them in this ban. There were more judicial reverses, including adverse rulings at the Fourth and Ninth Circuits. And by the way, I should add that today I'm filing a brief, an amicus brief for immigration scholars in the Fourth Circuit in the latest iteration of the travel ban litigation, assisted in that by wonderful lawyers at Wilmer Hale. But that litigation got cert granted in the Supreme Court. The Supreme Court then issued the somewhat Solomonic injunctive relief that Hiroshi alluded to. Then the Supreme Court proceeded to vacate as moot the underlying decisions from the Fourth and Ninth Circuit after the issuance, if you can stay with me here, of the third executive order in late September of this year. That order was different in a couple of respects. One thing, the countries were slightly different. So it added Chad. Why Chad? I have no idea. Okay? Chad is actually 40% Christian, and its government seems very vigilant in trying to combat terrorism. But for some reason, Chad is on that list now. Iran stays on the list, as does Libya. We add North Korea, which seems like an oddity because North Korea doesn't let anyone leave. Right? It also added Venezuela, but only with reference to relatives of officials in the Venezuelan government. It kept Somalia, and it dropped out Sudan, and it kept Yemen. Right? So that's the nations that are affected. The key thing, though, is that this ban, unlike the earlier one lasted only for 90 days. Right? It was temporary. This ban is indefinite, right? Subject to review at the administration's discretion, right? Every 180 days, right? There's a waiver process, but that waiver process seems mysterious and opaque. You have to show hardship. What does hardship mean in this setting? We don't usually ask relatives of U.S. citizens to show hardship to be admitted in the country on an immigrant visa. So it's the whole order then is anomalous under the Immigration Act and seems to me to be basically a kind of attempt to reinstall a de facto quota of exactly the kind that Congress tried to outlaw in 1965, that Representative Feigen felt convinced he was outlawing, and one that clearly runs afoul of the non-discrimination provision that Representative Feigen of Iowa insisted on to make sure that you didn't have runaway executive discretion. We'll get decisions from the Fourth and Ninth Circuits after arguments are held in those renewed cases based on the third order. The arguments will be held in early December. I think because the Fourth and Ninth Circuits have had practice in this from dealing with Executive Orders 1 and 2, they'll issue their decisions quite rapidly, maybe by January. At that point, I think this case will end up back in the Supreme Court at some point in winter or spring.
Well, yeah, I mean, I'm taking your question. I hope this is fair to take your question as an invitation to sort of try to read a little more tea leaves into what the Supreme Court did or didn't do, you know, and, well, okay, I hope that's fair anyway. You know, the background here really is the plenary power doctrine, right? The plenary power doctrine makes it really very difficult to raise serious constitutional challenges to any immigration decision by the government. There are exceptions to it and workarounds, but that's really the fact. And so if you file a brief in the Supreme Court that says this violates the Establishment Clause, well, I mean, one of the government's responses is going to be, well, that may be for everything else, but not for immigration. So that's the background. So I'll make 3 quick points in response to your question. I mean, I think that this is a very interesting approach by the Supreme Court. It does seem to recognize the rights of citizens in a way that I suggested is more robust than ever before, and yet I'm not sure if it was really speaking to the merits. It's for a preliminary injunction decision. It was striking in how much, you know, those of you who work on this area know that preliminary injunction decisions turn a lot on the likelihood of success on the merits and also on the harm. There was a lot of discussion of harm, but not any really discussion of likelihood of success on the merits, and I'm not sure exactly that's how they got to the 6 votes. So I don't know if it's predictive in that sense. I also don't mean to suggest that if you recognize the rights of citizens in these cases, that the government always loses. I think that the one area where there has been a serious constitutional review in the immigration law area is when you have permanent residents in the United States, either in the country or returning from a trip, and asserting procedural due process rights. And in that context, the standard analysis is under Matthews versus Eldridge, and it is standard normal con law, but the government doesn't always lose. As someone who's been writing about the plenary power doctrine for a long time, I would be quite pleased with a decision that applies what I think of as normal analysis, where there can be a considered discussion about whether the national security interests have been shown in a certain way or not, as opposed to a blanket. The other thing, which I just raised as a question, is that implicit in this decision was the idea that trying to figure out exactly how the Establishment Clause figures into this, because the focus was on defining bona fide relationship to be people who have family relationships, employment, and educational relationships, but not refugee resettlement and not a religion-based bona fide relationship. And so that's another open question. So those are, if nothing else, I think 3 open questions that I think make the prediction about what to read in the Supreme Court decision actually more perilous than I first made it seem.
I wonder, maybe touching on the plenary power aspect, but also aspects of the INA, if you both might speak to, on the one hand, you referenced Section 1182, which is this wide berth of power to the executive in the area of immigration that government certainly cites in their briefs every which way. And then in the 1965 INA, Section 1152, which does place these limits in this anti-discriminatory provision. I mean, how do you see those tensions playing out in this case?
Well, 1182F is the provision that President Trump has relied on. And what that does is say the president can bar the entry of foreign nationals when he deems that entry to be detrimental to the interests of the United States. Okay? That was one of the provisions added in the 1952 Act. But like many statutory provisions, that didn't get enacted in a vacuum. Right? There are antecedents there. Most of those are actually wartime antecedents. Woodrow Wilson asked Congress for authority to bar the entry of foreign nationals during World War I. Congress gave him that authority, but Wilson targeted subversives, spies, etc. He didn't target, people generally from foreign countries. It was a very tailored kind of proclamation that Wilson issued. During World War II, President Roosevelt sought the same kind of authority. Congress actually pushed back, and here there's another Ohio story in the mix. Senator Robert Taft of Ohio, lion of the Senate, great Republican, said, no, what the president wants is just too extreme, because it's not clearly limited to wartime. He seems to want the authority, which Taft described as extreme, to summarily exclude anyone at any time if there's any war anywhere around the world. And Taft said there's pretty much always going to be some kind of war, and so we're basically ceding to the president wholesale authority to exclude anyone the president doesn't like. Taft said, no, that just can't be. It's not consistent with what Congress has done here or what Congress should do. In response, Democratic members of Congress and the administration said, no, that's not what we have in mind at all. We want a far more tailored brand of authority that will simply give us the authority that Wilson had in World War I to exclude subversives, right? People who are planning to engage in sabotage or in espionage in the United States. That's all we want. It was on that basis that the legislation was passed and that Roosevelt issued a subsequent proclamation that targeted just those groups. So that, again, was very tailored relief. That brings us to 1952. And Congress then, in peacetime, enacted 1152, the President's authority to exclude folks who are detrimental to the United States. Right? But our point in this brief is that it would be very odd for Congress to have given the President, in peacetime, vastly greater authority than presidents like Wilson and Roosevelt, wartime presidents, demanded for dealing with the exigencies of armed conflict. Right? And so you have to narrowly construe, we argue, the delegation to the president in 1182F. That is also consistent with time-honored cases going back to the Endo case that I mentioned this morning, Frank mentioned as well, saying that it wasn't within the delegation to the president to detain conceitedly loyal Japanese Americans. Same thing with Kent v. Dulles, where the Supreme Court said in 1958, another Justice Douglas' opinion, President doesn't have authority to summarily revoke the passport of a U.S. citizen for proclaiming political views that the president doesn't like. That's just not within the statutory delegation. So ultimately, for me, this is a point about the scope of delegation. I think that has to be tailored, and Trump's view completely, goes well beyond that tailoring. It really says, we're not interested in tailoring. We want the authority, in effect, to summarily rewrite the entire immigration law, so that if we don't like particularly a visa allocation, we can just replace it with a scheme of our own. If we don't like the grounds for excluding people, which we currently exclude terrorists, say, or criminals from other countries, we want to add to that. Again, target people we don't happen to like, we're free to do that as well. That's the kind of delegation I think far exceeds the scope of tailored authority that Congress provided to the president.
Well, let me respond to Avi, your question by asking Peter a question, okay? I mean, to what extent do the idea that there are limits that in 212F, that there has to be this showing, to what extent is that simply a matter of time and of process? I mean, one of the things that's going on in the DACA litigation right now is that one of the arguments against the DACA being brought up in court to contest the rescission of DACA is that the president in doing that, or Jeff Sessions in doing it, didn't articulate the right reasons, right? But the resolution could easily be that there's another decision that articulates the right reasons. And so to the extent that the statutory problem with this executive order is it didn't do what you're supposed to do, I mean, I'm not sure I really have any serious doubt that the president would make those findings somewhat along the lines, and then it's a question of delay. It's a question of when, not whether. Or am I looking too, am I not giving enough credit to the statutory non-discrimination argument?
Okay, so again, just slightly more background. DACA, as probably everyone knows here, is short for Deferred Action for Childhood Arrivals. That's a program for so-called dreamers, that is folks who came here when they were kids, brought here by their parents, no voice in the process. President Obama then decided to give these folks a reprieve from deportation and also make them eligible for work authorization. There are 800,000 young people who now have gotten the benefit of this program. President Trump has declared his intention to rescind it, right? Those folks are in a fundamentally different position, I think. Although I think the DACA program is a great program. I think it's a legal program. I've signed a letter from 100 law professors, I think Hiroshi signed that as well, saying it's legal. We urge President Trump to retain it. It struck us both as odd, I think, that President Trump, who is litigious by nature, decided to fold his tents instead of litigating this case when states like Texas said, oh, we're going to sue you. It seems odd for President Trump to say, oh, you're going to sue me. I just cannot possibly deal with that, so I'll just do exactly what you want. Pretty much the only time he's done that, right? But these folks are in a different position because absent the relief that President Obama wisely and legally provided, these are folks who don't have a legal status in this country because their parents weren't lawful residents or citizens. They don't have other, by definition, have no other close relatives who are lawful residents or citizens. They're not eligible for family-based immigration. Not only do they have a status, they really have no pathway to a status, right? In contrast, the petitions for immigrant visas in the travel ban case are folks who otherwise would be able to get visas, right? Because they are close relatives of U.S. citizens or lawful residents, right? The only reason they wouldn't get visas is because a consular officer said they weren't who they proclaimed to be. They weren't really that close relative or someone else, or if they were subject to some kind of inadmissibility ground like being a terrorist. Otherwise, they get their visa. So Trump's actions with respect to the travel ban upend the entire statutory scheme, right, that Congress enacted largely in 1965. While the DACA program was really an attempt to supplement that scheme, I think it was legal, but it was still an attempt to supplement it. So I think they're fundamentally in different situations.
Right, but I'm trying to raise a distinction not between the position of the people who would be beneficiaries or not of the program, but rather between reasons that the president failed to comply with but could. And, do you not think that the president would do the things that now these courts seem to think he needs to do before he invokes this sort of exigent circumstances exception?
To me, the central problem with the third version of the travel ban is the indefinite nature of the bar on entry, right? If this were a true temporary ban, Trump said, 90 days and that's it. I just need to figure out what's happening in the system. Maybe our consulates aren't getting the right information. Let's check in and make sure. I personally would say that's probably all right. I wouldn't like it. I don't think it's necessary. But I'd say it's probably within his authority under the statute. It's the indefinite nature that, to me, is a structural challenge to the underlying statutory scheme. So that's where I have the problem. And I don't think findings remedy that, because I don't think you can make findings that would deal with this. Plus, just to flesh this out, the findings that Trump made in the third version of the order don't make sense at all. Right? So give you a quick example of that. One of the things cited in the order is, well, the countries we've listed, Somalia and the rest, don't do proper identity management, right? Not true, right? One of the things targeted there was identity management, meaning you report lost or stolen passports. Do you have electronic passports? It turns out that Somalia, I honestly didn't know this, Somalia issues electronic passports. Right? On the other hand, there are probably 100 other countries around the world, more, that do not issue electronic passports. Many other countries in that vein are not on this list. Similarly, there are many countries that do not take back their nationals when they've been ordered removed from the United States because they committed crimes or the like. There's one country on the list in the third executive order that does that. That's Iran. Iran is very careful about taking back its nationals. Why? Because they're criminals. So why would Iran want to take them back? Right? But there are 100 other countries that are not on the list that also stubbornly refuse to take back their nationals. Right? So this list, if it is in fact a list, is highly under and over inclusive at the same time. Those are usually traditional hallmarks of discrimination. Right? That's the way this list operates. So if you look at it strictly in terms of traditional means and fit, it doesn't pass the test.
I guess this speaks to one issue. It seems that the court would be more likely, of course, to, I think, rule ultimately on statutory grounds than address the Establishment Clause and perhaps invite some of this constitutional understanding of what defines citizenship. Do you think that's the likely outcome?
Well, I do think that that's more like, I'm sure the court is going to look for something, a statutory or some form of subconstitutional ruling, and I'm also fairly confident the court will try to come up with a ruling that may be isolated to this set of facts or this moment in history. That said, I think that a lot of the statutory interpretation at play in this case is extremely heavily influenced by constitutional considerations, and so there will be a decision that if it's statutory, it's going to be reminiscent of several Supreme Court decisions, actually a line of Supreme Court decisions that spend a lot of time talking about constitutional rights and then saying, because these are serious questions, we're going to rule on statutory grounds, right? And so that means Zedvitas versus Davis in 2001 is a case like that. There's a case called Jean versus Nelson from 1985 in the Supreme Court, where the Supreme Court reads a non-discrimination clause or a norm into regulations on the detention of patients. And this really goes back even to the earliest days of constitutional immigration law. Yeah. So I'm not sure I'm making a prediction of outcome, but I'm making a prediction about modality and attitude.
Yeah. But I guess I wonder, the argument you were making with respect to 212F, in terms of the level of deference that might be given to whatever the fact findings are, or maybe if there were even further perfected fact findings, maybe they would defer, seems to play out similarly in the constitutional realm, right? I think it's in Kerry versus Din, the language about essentially deferring to the court, right? Unless there were
right.
Was it legitimate and bona fide
right.
reasons?
Right, and that could result in the government, winning. But it's interesting to see in this case much more robust argument that unlike the quote normal case end quote, this is a case where it is perhaps not legitimate, facially legitimate, and perhaps not bona fide. And so. Yeah, and then another way to answer that, maybe the first part of the way you phrase the question is to really think about, to bring it back to Executive Order 9066, right? And so, one of the things that I think is very much at play is where I started, which is the concept of the non-alien, right? And sort of that was going on in Korematsu. So if you think about this as a case that's very connected to that episode, then I suspect that one of the things, of course, I don't know what was motivating the 6 justices to vote for framing the preliminary injunction this way, but there is this sense that we need to recognize people in a way. I just don't know how much they were thinking about the phrase of non-alien in Korematsu, but I want to mention the brief from the Korematsu Center at Seattle University. Bob Chang, we'll hear from in a bit. I mean, I think it very much hits on this point, right? That one of the things going on at stake here is an echo of what happened. Not just an echo in general historical terms, but an echo on the recognition of what it means to be a citizen would be to have your interest in decisions, to have the harms, the interests, the harms that you may face in immigration decisions, such as before the court now, recognized. And that's what fits into sort of my own, admittedly, it's my framing of this, is really to think about, where we find immigration law. Where do we find, I mean, I think that, you find immigration law in places where you don't necessarily expect to find it. You find it in the Homestead Act, or you find it in the things you count and don't count. You find it in employment, and you certainly find it in the recognition by courts of what is really a harm that should be considered. So that's a way to bring it back. To answer your question very broadly in the context of the Executive Order 9066.
Thank you. I want to open it up to the audience, if I may. There are questions that we can take for the speakers. Just wait for the microphone. I think we have one right in the front row, Professor Forte.
Peter, thank you very much. This is not my area, so my question, please take away my ignorance. Between 65 and the present day, were there some modifications to the immigration law? Was a lottery put in?
Yes.
Could you fill out a little bit of that?
Sure. There have been changes. They don't affect the analysis here, in my view, but there's certainly been changes. It's a living statute. So you have a diversity lottery. That's something that President Trump has attacked because it appears that the person who tragically used his vehicle to kill a number of folks in Lower Manhattan a couple of weeks ago got in through the diversity lottery. That was a program instituted by Senator Kennedy, because he felt that since family-based immigration depends on people who have close family members who recently immigrated here, that the trends in immigration have shifted away from traditional immigrant countries like Ireland, say. Why would Ted Kennedy have an interest in Ireland? I don't know. You'd have to fill that in. But he said, well, that's not good, and so we want to redress the balance. And so he said, we'll have diversity lottery for countries that are now low immigration countries like Ireland. It turns out actually that the program has worked more to bring in folks from places in Africa, say, which are also historically low immigration countries. So those are the folks who benefited from the lottery. I think the lottery is a good thing. I think immigration generally enriches us. I think the diversity lottery does as well. We've also had changes that have made the immigration law much tougher for people already here. So I mentioned criminal grounds for exclusion. There are also criminal grounds for deportation. And those include things like aggravated felonies. Aggravated felonies can be anything from a crime of violence to drug trafficking, counterfeiting, fraud. Congress in 1996 added exponentially to the list of aggravated felonies. The import of that isn't just that people are removable, but that they have no relief from deportation no matter how long they've been here as lawful residents. So you could have someone who's been here as a lawful resident for 40 years. That person commits an aggravated felony. That person is on the fast track out of the USA. Right? So that person, even though he's been here for 40 years, is treated markedly differently from a citizen who's committed a similar crime, who does his time, and that's it. So Congress has made the immigration law harsher, but not in a way that deals with the fundamental concepts of the 65 Act, which were getting rid of national origin quotas and prioritizing family reunification.
How many in the lottery?
I think it's 50,000 slots annually.
They originally reserved by law in a way that went 40% to Ireland, but that was the original version.
Question there.
You briefly mentioned DACA, and it doesn't sound like either of you or all three of you are very optimistic that it's going to help, the litigation process is going to help those DACA students.
Well,
Dreams.
I think it will help them. Whether it'll succeed on the merits is another story. I think it will definitely help them by bringing to public attention the very compelling stories of these folks who've made something of themselves against great odds, who developed lives, careers, who've served America, done a lot for this country. I was on a panel with a DACA recipient about a month ago at Roger Williams Law School in Rhode Island, where I teach. This person was a lot smarter than I am, I'll tell you that. He was a computer scientist, but he also talked about law in a way that struck me as exceptionally sophisticated. Again, probably better than I could do. So these folks have done a great deal for this country, and getting those stories out there is helpful for the political and the social debate. But on the merits, I think it's going to be difficult to prevail. Just a very quick example. One of the arguments made is that the rescission can only be accomplished through notice and comment under the Administrative Procedure Act. And often I think that's a good argument to make. The trouble here, though, is that the Obama administration didn't go through notice and comment to initiate the program. Right? Why? Because notice and comment takes time, takes 8 to 12 months at least. Who wants to do that, right? So they just announce the program and implement it immediately. To me, it's at least somewhat incongruous to say notice and comment is required to end a program when it's not required to begin it.
Yeah, I mean, I think that the difficulty here, to pick up a little bit where Peter left off, is that the argument being made here is to put limits on the rescission of a program that was discretionary to start with, right? I don't think that is such a impossible thing. I mean, there's certainly times when one can imagine a program being rescinded for reasons that are impermissible, even if the program itself was discretionary, right? If you were to rescind it only as to a certain ethnic group, for example, I mean that's a simple thought experiment example of that. And I think that what the plaintiffs in the DACA litigation are doing is making a very strong case for how much harm it would cause to eliminate DACA. But I think what you may be getting at is the emphasis on the harms, but not on a theory of liability or limitation, right? And I think that as long as this is seen as a program that was a temporary reprieve and we're doing this, as long as DACA is characterized that way, it's going to be hard to make the argument. My own personal view of DACA is really not that. I think that DACA was, I think this is somewhat of a forgotten story, is I think DACA was adopted by the Obama administration in large part because of field office resistance to its attempts to impose prosecutorial discretion guidelines. And so I think of DACA as a rule of law move to prevent inconsistent, opaque, and potentially discriminatory enforcement. Seen from that perspective, I think that it becomes a stronger case for limitations, especially when you have the counts in the DACA litigation more strongly in New York than in California litigation on how this is driven by some form of racial animus, although I think the record is weaker than it in the Muslim, anti-Muslim rhetoric. To combine that with sort of the more free-for-all enforcement regime that we have now, then it starts to look like an argument saying that mirrors the argument against laws that are unconstitutionally vague. Now, those are the arguments I think that need to be made in order to set up limits. I don't think it's enough to do, as the plaintiffs have tended to do, focus on the degree of harm that would be caused. So, to the extent that I personally am hopeful that DACA's rescission can be blocked or tempered, I think it needs to be based on a more robust theory of what are the limits on this.
Well, I wonder, Hiroshi, to go back to sort of your notion of of citizenship being, I guess, defined across the borders.
Right.
You know, is there, it seems to me, I'm pretty sure Justice Scalia raised issues with the notion of how to define that right in Kerry versus Din and what have you. Pushing against that, how do you respond to those arguments?
Well, this is something that I think is a tough question that, I'm going to fumble around with the answer here because this is something I've been really struggling with. So I'm working on this book project that really tries to deal with a lot of different issues. That's why it's called Migrants, Refugees, and Citizens, right? And I think, and the book starts with this notion of whether or not we can think of immigrants' rights as a civil rights question. And I think that's become a dominant frame, at least in certain types of, certainly among lawyers, certainly perhaps among, loosely speaking, immigrants' rights movement that feels itself grounded in the civil rights movement. And so that move tries to do the kind of thing that I tried to identify in what the Supreme Court may have done in saying, let's look at the effects on Muslim Americans, who are multi-generation or just people who are already here. And I think that that framing potentially comes up to limitations that I think your question may expose. One is that a lot of the issues and the pressures that have been put on societies like the United States, we've certainly seen this throughout the world, certainly in Europe, comes from populations that don't necessarily have connections here, refugee flows, for example. And so what does the civil rights frame do for that, right? But the other thing is that and this may be like getting to the toughest part of your question, is if you really recognize the rights of citizens across borders, U.S. citizens that have interest in people coming in, is that the end of the border? Is that really the end of the border? And I guess the answer would have to be that not if you think the government always loses in that frame, right? I think that there may be ways to define discrimination in a way that is respectful of rights in the country, and so that I'm imagining immigration law and a constitutional law of immigration that does preserve a border and does discriminate, but not on the basis of anything other than citizenship itself, and that there is a serious scrutiny of when, for example, there is national security exigency, or when there might be some justification for having a diversity lottery. And so I don't think it necessarily means the end of the border, but I do think that it is more complicated than a world in which everyone on the outside was regarded as having no relatives on the inside. It's much more complicated than that, I recognize, but I do think it is a better substantive result than to imagine citizens without foreign relatives.
Yeah. Though I guess it would be that sort of collateral litigation that Thomas and Alito and Gorsuch were sort of up in arms about.
That's right. I think it's clear that they didn't want to get into that. They wanted to imagine. The Kerry versus Din case, which I think you're basically have in mind as you ask some of this question, is the Kerry versus Din case involved a woman, family name Din, who was petitioning for a husband in Afghanistan, and so Scalia writes for himself and Chief Justice and Justice Thomas, I think, three, saying that, she can get married, but she can go live in Afghanistan or someplace outside the United States. And so because I don't think they want to really get into the border crossing implications of the recognition of U.S. citizens' rights. Now, I also wonder, and now I'm getting into sort of thin ice with respect to sort of my particular expertise, but I'm thinking about what effect Obergefell has on this, and on not only on the recognition of the family, but the non-insistence that Obergefell move to another state, and so I'm wondering. I think that in a robust trying to read the Supreme Court's recognition of of citizens' rights in the immigration context, to read that for all it might be worth, one would combine the 6 votes for looking at citizens' rights in Kerry versus Din with the court's decision in Obergefell talking about the family, and in particular the geographical implications of the protection of the family. And this is why it may be different from Fiallo and Mandel 40 years ago. But you're right, that's really what the 3 justices who lead off the court's rendering of opinions, but it turns out that they're the only 3 justices that don't recognize that there is some need to look at the impact of the immigration decision on Mrs. Din.
Thank you, Roshi. Thank you, Peter. I'm afraid we're going to have to end right now. Are we taking a break after this? Okay, so we will take a break, but please join me in thanking our panel. You got it.